Well, I think we've given a reasonable opportunity for people to join this webinar. My name is Barry Coulter, and I'm presenting this webinar with, or in company with Daniel Searle. We're both barristers at Goldsmith Chambers, and this webinar, like all webinars provided by Goldsmith Chambers, is available on the website. So for those of you who would like to watch it a second time, not quite sure why, it's available there. And if there's anybody you know who would be interested in seeing the webinar, then go on the website and you will be able to find it. The topic of this webinar is some practical personal injury and employment pointers. I shall be dealing with mainly personal injury and Daniel with mainly employment. And we're dividing this webinar up into two halves. As you might guess, I'm dealing with the first half. You'll also see that we're delivering it from our coronavirus quarantines in my bedroom and Daniel's living room. If you have questions that occur to you during the course of the webinar, don't hesitate to use the chat or questions and answer buttons. And if we have time at the end, we'll answer them. If we haven't got time at the end and you've put your email address on your questions, then we'll endeavour to answer them in due course. And there will also be a handout prepared by Daniel, I hasten to add, available shortly after the webinar. So with no more ado, let us move on to some practical personal injury and employment pointers. It arises out of the coronavirus. Well, let's have a look at the beast. Know your enemy. Here is an artist's impression. I'm not sure who the artist was, but it's a pretty gruesome impression. So enough of that. Let us now move on to the practical pointers for practitioners. From the employer's point of view, the coronavirus brings no new burdens or duties really. It remains the old duty, and that is the duty to keep the workplace reasonably safe. All employers have always had the duty to take reasonable care of the health and safety of employees, the duty arising both in tort and under the Health and Safety at Work Act, and as an implied term of the contract. This, of course, includes the crucial duties of providing safe places and safe systems of work. So no difference there with the coronavirus. What does it mean for practitioners if someone has a coronavirus potentially related condition and they come to see you? Well, we go then to the regulations and the guidance. The regulations, Coronavirus Regulations 2020, these are the well-known and draconian regulations introduced by this government to prevent people moving about the country and potentially risking others by spreading the disease. Very powerful and perhaps controversial regulations, but in terms of our concept of personal injury, they're probably not going to have a great deal of effect. What will have a great deal of effect, however, are the guidance provided by the government, because all employers will need to deal with this new condition that they face and protecting their employees. And the government has very helpfully provided these 8 sets of specific guidance for specific industries: construction, factories, laboratories, offices, other people's homes, restaurants, shops and vehicles. Should a potential client come and see one of the practitioners and you can identify an industry, then I would urge you to go to the website, find the specific guidance, and it really will give you a lot of help on what an employer ought to have been doing in their specific industry. If you have numbers of clients from a particular industry, it wouldn't do any harm to make yourself aware of the content of this guidance, because all employers should be aware of the content of this guidance. And if they're not carrying it out, then that may well be your first point of call for a breach. Of course, the guidance, as with regulations, carry no civil liability in or of themselves, but what they do is provide, or probably will provide, the foundation for evidence of what the duty of an employer ought to be when applying the reasonableness test. So these are the guidance. How do we apply the guidance? Helpfully, the government has provided yet another set of general guidance, and we have that here, and it comes from a document called Working Safely During Coronavirus. And this document, Working Safely During Coronavirus, sets out 5 very basic and sensible steps for all employers to take. Carry out a COVID-19 risk assessment. Well, a COVID-19 risk assessment is likely to be necessary for not only coronavirus in and of itself, but every risk assessment that has been carried out so far ought now to be reassessed in the light of the coronavirus. And if you have a potential claimant who comes through your doors and the employer hasn't got an up-to-date risk assessment dealing with coronavirus, then that certainly is a powerful tool when demonstrating evidence of a breach. Develop cleaning, hand washing and hygiene procedures. I'm sure we're all doing that to whichever tune we like now. Help people to work from home. And here we are demonstrating how we've helped ourselves to work from home. Maintain the 2-meter social distancing where possible, where people cannot be 2 meters apart to manage the transmission risk. Well, we all know about this. But these are very practical steps that all employers should take. And it is against this 5-step background that the courts are likely to look at the specific guidance we looked at earlier, those 8 specific areas. An interesting feature, I thought, of the 8 areas we looked at, the 8 guidance, is there are 2 that I think are missing. One of them is care homes and the other is the NHS. You may think that care homes and the NHS are particularly important areas where guidance would be required, but none seems to have been provided by the government yet. So we're doubtless going to have to apply or adapt the guidance given in for other areas. One of the features of the coronavirus is PPE. If we move along to the next guidance, here we have 2 well-known chemists carrying out their functions with the use of what looks like quite comprehensive PPE, but as you can see, they're not wearing it properly because they're not wearing their masks. PPE is going to be available, or is available, in vast quantities in equally vast varieties of guises. A search on the website will produce, or any website on Google or Bing or whoever, will produce vast quantities of PPE, and no employer will be able to say that they weren't able to find it, fund it, or provide it, because it's all going to be available, and the cost is whoever the employer is, the cost for particular PPE will be within their budget. The absence of PPE is going to be a definite alarm bell for any employer whose employee is injured as a result of coronavirus and comes through your doors. Coronavirus and PPE are part and parcel of this area of litigation, and one of the features that employers are going to find is that employees may feel concerned that whatever the level of PPE, maybe it's high, maybe it's low, that they do not wish to take risks. In those circumstances, we come to the question of lawful orders. And if we move on to lawful orders, I have set out here the wide bracket where an employee is at risk of being summarily dismissed if he or she willfully disobeys a lawful and reasonable order of the employer. Now, this might be of more interest to employment lawyers, but it does have an impact in personal injury litigation. But dealing with them, the range. We have Ottoman Bank and Chakarian. In Ottoman Bank, Mr. Chakarian, an Armenian, had been sentenced to death by the Turkish government, and his bank required him to go and work in Constantinople. Mr. Chakarian, not surprisingly, thought that was a risk he didn't wish to run, and the House of Lords agreed with him and found that it would be unfair to dismiss him in circumstances where attending work resulted in death. In the second case I have there, Bukoke and GLC, that's a less, or rather more prosaic case, but equally important, or perhaps more important in present circumstances. That's a case where the Fire Brigades Union attempted to have a rule or employment rule imposed by the GLC that required fire engine drivers to drive through red lights, and the Court of Appeal upheld the High Court and said that it's perfectly reasonable for fire engines drivers to be dismissed if they refuse to drive through red lights, even though driving through red lights in those days for a fire engine was a criminal offence. So the question for the court is always going to be, on the facts of the individual case, what is reasonable? So when somebody comes and says, I'm not going to work in that factory or in that office or in that laboratory or care home or whatever it is because of the risk of suffering from coronavirus, the question is one of reasonableness. We now move on to the tests that employers impose. Employers will, I'm sure, from the very start of the end of the lockdown, have a fabulous system and spend a lot of money on designing protections for their employees. But a danger arises when employees become blasé, as all employees do, and they become careless of their own safety and careless of the safety of others. And although there are rules, they don't obey the rules. What happens then if one employee either becomes ill themselves or infects somebody else because they have disobeyed the rules the employer has imposed? Well, the law is that an employer is required to enforce the rules, and it isn't good enough to say, I had a system, I had PPE provided, and the simple fact is that one foreman or one employee or minor employee disobeyed the rules. The employer, the boss, is still responsible, because it's the boss's duty to ensure that all employees comply with their duties, and that necessitates that all employees not only devise a safe system, provide equipment, but that they also ensure that this guidance rules are reinforced. If you don't reinforce, then discipline is lost and claims will be made. I hope some of those were helpful pointers. As we say, there will be more information on the handout, but now if I could give some time to Daniel.
Thanks, Barry. So as Barry said, I'll be discussing discrimination and whistleblowing, specifically in the context of a return to work and as lockdown restrictions ease. So why is discrimination so important in the current circumstances? Well, if we look at the government's social distancing guidance, and specifically at the list of those considered clinically vulnerable, well, what we can see is that each category either is or has the potential to be a protected characteristic under the Equality Act, specifically the characteristics of age, pregnancy, and depending on the circumstances, disability. So having said that, it's obviously very important that employers consider their return to work policies in accordance with the Equality Act. So let's have a look at some of the applicable sections with a particular emphasis on disability discrimination. So there you'll see indirect discrimination, section 19 of the Equality Act. So there'll there could be a whole host of PCPs which employers can implement in the coming weeks with the potential to breach Section 19. For example, a PCP that all employees must now attend work runs a real risk of causing indirect discrimination. So in that example, all employees must now attend work. What can an employer do to avoid breaching Section 19? Well, if home working roles do exist, and if the business model permits, the employer should consider ring fencing those roles for those with protected characteristics and for those who do require home working. Now, that PCP that all employees must now attend work is a prime example of a PCP that pre-lockdown would have been perfectly consistent with the Equality Act, but post-lockdown, obviously that PCP may not be appropriate. So the key takeaway is that business can't continue as usual. Employers should really scrutinize their new PCPs and their existing PCPs that will be reintroduced. So let's take a look at discrimination arising from disability, Section 15. Now, one of the more important aspects touching on Section 15 will be the application of attendance reviews. So many vulnerable people will be shielding right now, and indeed they may be shielding for some time to come. So where disability related absence or shielding related absence tots up and results in an absence management review, that does have the potential to breach Section 15. Both absence management and dismissal are, of course, unfavourable treatment for the purposes of the Act. And in order for those actions to be lawful, an employer must show that such action was a proportionate means of achieving a legitimate aim. So it's all about striking the right balance. In this particular circumstance, whether shielding-related absence should count towards an absence management review, you'll see I've put on the side there some considerations for the employer: likelihood of an imminent return to work, reasons for the absence, nature and extent of the absence, and whether reasonable adjustments can be made to improve attendance. That brings us nicely on to the next section, reasonable adjustments, Section 21. Now, there's specifically in relation to disability discrimination, there is a real risk that employers can breach this section if they fail to facilitate home working for those with a disability and who need home working roles. Of course, if there are no home working roles available, there's not necessarily a breach of Section 21. So it's all about reasonableness. Now, I've put the HMRC case on the slide. That's the case of the EAT, which held that the purpose of reasonable adjustments is to facilitate a disabled employee remaining in work or returning to work. So as such, it's not necessarily a breach of Section 21 to fail to pay a disabled employee who self-isolates before seeking medical advice. Again, this comes down to reasonableness. So tribunals are unlikely to be favourable to an employer who fails to pay a disabled employee who can't attend work because they're shielding. Again, it's all about reasonableness, the size and resources of the employer, relevant considerations, and the tribunal will, of course, look at that. Now, when an employee refuses to attend work because of an increased risk due to their disability, employers should seek medical advice either from the employee's GP or occupational health. And such advice should clarify potential risks and set out any reasonable adjustments. But of course, where the matter's urgent and there's no time to obtain medical advice, employers should err on the side of caution. So what's the position where the employee themselves are not protected by the Equality Act because they don't have a protected characteristic, but they live with someone who does have a protected characteristic? Well, I've set out the government's shielding guidance on the slide, and what that does is anticipate social distancing from within the home. So if there is someone at home who needs to shield, the government anticipates that self-isolation within that home will be sufficient and others will not need to shield. So that may or may not be a practical solution depending on the circumstances. And in many cases, it won't be a practical solution. So of course, this does place a burden on an employer to be sensitive to concerns and requests raised. The law on association or associative discrimination is inherently narrow, so it doesn't protect against a failure to make reasonable adjustments or indirect discrimination or discrimination arising from disability. It's very narrow and is only applicable in direct discrimination, harassment, and victimization. So you can see on the slide there, I've set out some practical steps for both employees and employers. I don't intend to go through these in any detail. We've been through some of them, and indeed the slides will be uploaded to the website later. But I do have two quick points that I want to focus on. The first is in relation to reasonable adjustments. Now, Section 21 imposes a proactive duty. So it's not a reactive duty where an employer can just sit back and wait for suggestions from the employee or wait for a problem to present itself. It's a proactive duty. As soon as the employer is alerted to the fact of a disabled employee, they should act then to make any reasonable adjustments and shouldn't wait. So linking with that is practical advice for an employee. Of course, there may be employees with a disability who didn't feel the need to tell their employer pre-lockdown about their disability. It could be a case where the disability doesn't affect their working life. But of course, the lockdown and coronavirus has brought matters to the fore that weren't there previously. So there is a renewed need for employees to alert their employer as to the existence of any potential disability. Now, the second point of practical steps, even if a person isn't protected by the Equality Act, they may have an illness which makes it unwise for them to attend work or indeed to travel to work. Now, where there are straightforward solutions which an employer unreasonably refuses to implement, and that unreasonable refusal goes to the heart of trust and confidence, there may be a case for an employee resigning and claiming constructive dismissal. So that brings me to the end of discrimination. I just wanted to focus on whistleblowing for a few minutes. There have been numerous reports in the press of employees, NHS trusts, telling their employees not to raise concerns, primarily regarding PPE. Now, this request is completely runs contrary to the spirit of the Act, and especially during the course of the pandemic. So concerned employees, regardless of the management instructions, should be raising protected disclosures just as they would usually. Just a few quick practical steps for employers. Obviously, there's a lot going on right now. There's a lot to grapple with. It may be a sensible idea to appoint a designated person, preferably from HR, who will deal with protected disclosures. And obviously this will be more relevant to employers where situations where PPE is required or where social distancing isn't possible. Finally, in regards to an employee who does make a protected disclosure, if an employer further down on the line determines that that employee is suitable for furlough, well, that could be seen as a detriment arising from the protected disclosure. So in that circumstance, employers, as always, should make detailed notes and document their reasons why they're choosing certain employees to place on furlough. And if possible, the employer should top up the pay by the additional 20%. If the employer does that, then this obviously diminishes any argument as to detriment. Okay, well, that brings us to the end of the presentation. As we said earlier, we'll be looking at some of your questions. So let's have a look at those.
Well, Daniel, I've had a couple of questions. I think I've answered one whilst you were giving us our talk, but I've got another question here which is quite interesting, and it's from Renu Sangera at Lawrence & Co. And he says, regarding PPE, if an employer and employee disagree on the use of provision of work equipment, what is the answer going to be? Can an employee insist on bringing in their own PPE, or what is the mechanism for resolution? It's there are a number of sub-questions, and I don't think I'm in a position to answer it quite as confidently as I'd like to be on the cuff. So I shall send Renu an answer to that, and the answer will also be in our handout.
Okay, so there's a question just come in about disability, so I think I'll deal with that. If an employee's condition does not appear on the vulnerable people list, then how are we to know whether they're disabled? Well, the simple answer is the Equality Act still remains. It hasn't changed in any way. The definition of disability hasn't changed. And just because someone doesn't appear, or their condition doesn't appear on the list of vulnerable people, does not make them disabled.
Right. Well, I think that we've dealt with some of the questions, and as I've said, Daniel will be preparing a handout to go with the webinar. I hope you found this interesting. If you have, please tell us. If you haven't, do the same. Information is very useful, and we will endeavour to improve and any aspect that is practical in relation to our webinars. This is a new set of webinars, and I hope you bear with us in our early days where there may be teething problems, but thank you for attending.
Thanks all.